focus on partnership and companies. But it's important we have knowledge of other types of business organization so we can identify when we have a scenario in front of us, we need to know this nature of the relationship. So today we will review the difference between partnership and joint ventures. Partnership in the common law concept is an ordinary partnership, is a partnership composed of a group of people or individuals. So we will have some scenario when we're referring individual, whether it's a natural person or corporation, so we will need to identify, because from the definition it appears to be easy, but in the actual scenario, confuse can arise. So we look at the definition of partnership. So it's a group of people, they decided to form a business for a common object. So conduct some activity. This is the general definition. So the Partnership Act 1892, New South Wales, in this subject we abbreviate as PA 1892. So under this legislation, there are 3 different types of partnership. A partnership, a normal general partnership, a limited partnership, so this type of partnership need to be registered, or an incorporated limited partnership, so also required to be registered. So difference between those different types of partnership, we will need to review the definition under different legislations. But for the general partnership, we will find the definition in the Partnership Act. For a limited partnership, so we can check the legislation. Fair Trading Registry is regulating some type of incorporated limited partnership. So incorporated limited partnership, so this term incorporated, last week we referred to, or also will be referred to very often in this subject. So what that means, incorporated, is the law give a legal status to the entity. So incorporated, when we're referring to like a legal person, so for example, company, corporation, it is an incorporated entity. They have a legal status which is given by the legislation. But when we refer to unincorporated entity, so partnership is an example, but within the partnership we have limited partnership, incorporated partnership. So in the world we can explain, and this entity, they have a legal status, we call incorporated limited partnership. So there are 4 different types under the legislation, but we not go into the detail here, but you're welcome to look at the different nature and requirement of different type of partnership. We mainly focus on general partnership, so very important when we doing our exercise, we referring to general partnership, right? Not the limited partnership or incorporated partnership. So when you look at the Partnership Act, I upload to the Moodle site, so we only to the certain sections of the partnership, they referring to the general partnership. Okay, so Section 1, important, Partnership Act, define what means partnership. So partnership is the relation which exists between persons carrying on a business in common with a view of profit. So, and this description, there are very important elements which give us indication when we decided whether a relationship is a partnership. So we will look at the detail and break down those three important elements to look at what the law required to regard a relationship as partnership. So the governing laws of partnership is in New South Wales is Partnership Act, and also there are common law, particularly contract law. So when we look in the partnership nature of the partnership, so generally it's a contractual relationship. So a group of individuals, they form together to conduct business. So the general relationship is a contractual relationship. So contract law also regulate this partnership as well. So issues to consider. So are there any special requirements to form a partnership? So for example, is that necessary? You need to have a contract or in writing a deal of agreement to form a partnership? So what type of business organization is a partnership? Incorporated or unincorporated? Why this is important, we need to identify the nature of partnerships is incorporated or unincorporated. So this is related to the liability of the partners. So what liability do members, partners in a partnership have? Those issues are important. So, for example, we just review the definition of partnership is relations exist between persons carry on business in common with a view of profit. So as long as a relationship satisfies those definitions, we can say there is a partnership exists. But when we come down to the specific requirement, whether a partnership need to form in writing, so it's not necessary have to write down a contract to form a partnership. So it can be oral or by conduct. So in reality, we can see many examples. People just start to form a shop. They 2 or 3 together, so they start running the business. They may not necessarily prepare or draft a contract to regulate the obligation or rights between those members, but not necessary. And we think this relationship is not a partnership. But if you have a contract like you negotiate terms and conditions between the members, so and that will have the benefit of avoid future conflicts when disagreement occurs. So argument, so what he or she said before. So if you have a written contract or agreement under the Partnership Act, the partnership contract prevails over partnership acts. So the partnership contract is still important when disagreement occurs. So we'll identify and what's the rights and obligations and how the partners arrange and their, for example, partnership property and other when dispute occurs and how to resolve. So you can put those terms down into the partnership contract. So what type of business organization is a partnership? So a general partnership is an unincorporated business organization. So what that means, unincorporated, so they don't have a separate legal status. So we will look at the liability between partners. They are not a separate legal entity. So in New South Wales, partners, the liability is jointly and severally liable for debts of the firm. So what that means? What means jointly or severally liable for the debts of the firm, of the partnership business? So for example, in a domestic environment, wife, husband, they jointly to purchase a house, for example. So the value of the property, 400,000. So if they haven't specified what's the proportion they're going to share the liability, they join together, joint property, so their liability will be jointly liability unless they specify differently. And also another example like partner A, B, C, D, so they jointly promise to buy a house. So what that means, jointly liability. So they purchase jointly for the property. So we will look at the scenario, several liability. So each of the partners, it means promise to pay 25% of the value of the property. But in the partnership situation, when we're referring to jointly and severally for the firm's debts, so have an example, if there are 100,000 debts of the partnership's firm, so there are two partners. What that means, jointly and severally. So if one partner is bankrupt, so the other partner is liable for all the debts of the partnership. So it's jointly and severally. It's not in a proportion. It's not half-half. It's all each partner, they will wholly and jointly to liable for those debts. So we will have some example in the seminar to look at those issues. Three important elements under the Partnerships Act definition of partnership. So how we define whether a relationship is a partnership. So carry on a business in common with a view of profit. These are three very important elements to define a partnership. But in reality situation, how to interpret those nature of three elements sometimes can be confusing. So we have a look. The first one, carry on a business. Section 1B of Partnership Act, so define when they say carry on a business. So what that means, business, so includes trade, occupation, and profession. So that's what that means, carry on a business. So we might have other different example, so may not fall into this category. So we will be careful when we have a scenario whether that carry on a business, whether that business is under this definition. Carry on has been held to involve some repeatedness of actions. So we have case Smith-Anderson and also Griffin. So what that means, carry on. So there are essential and repetition normally is demonstrate carry on of a business, but sometimes not necessary. The repetition is essential. So we base on the facts of the scenario. So we will look at those cases, how the court interpret, carry on. So it's an isolated transaction is undertaking within the intention that will be the first of the several transactions. And this is enough to demonstrate an intent. So in this case, no repetition shows, but there is a demonstration. After the one isolate, there will be more come. So the court found and still regard as carry on a business. So while continuity of operation may be a strong indication a business is carry on, but it's no longer a critical consideration. So single transaction may be sufficient to form a partnership. So very important when we look at the three elements. So there are conflicting scenarios. We will regard carry on a business must be repeat, but not necessary. The case shows single transaction may be enough, sufficient enough. We'll look at the other two elements as well. So in common is the most important element of partnership. So we call it mutual agency. So mutual rights and obligations. So there are partners, they form the partnership. So we will look at the nature of this relationship, whether they have mutual agency nature. So what that means, mutual agency, we will look at how the arrangement of the business and how they share the decision making, how they involve with the business. So for example, if a person does not need to be involved in day-to-day management, and that means they don't have mutual agency relationship, it's not necessary. So sometimes we have sleeping partner, they're not involved daily management affairs, but they have other aspects and shows they have the mutual agency. So Ruddock, in this case, is another example. So in all other aspects, and they treat each other as a partner, even though Mrs. Bear didn't take part in the management of the business. So we can look at this case and see how the court interpret and what that means, take part in the business and mutual agency nature. This is another case. So there are three people, they involve business together, but two of them, they're insolvent. So the action was taken against another partner. So the court found there is no evidence of mutuality between the three. So important, in common, so we will look at some specific aspect of the relationship and whether they, for example, they join decision making or they not join decision making, but they have other nature, shows they actually involve mutual obligations. So, and that's the key. There are different cases on the different conflicting opinion, but we need to read. It's based on the fact and the circumstances. So in this case, it's no partnership exists. So no evidence of mutuality between the three. The third element is with a view of profit. So what that means is, so when the people form the partnership, they intend to make a profit. So, and that require they actually share the profit. So if the partnership make a loss, is that means no partnership exists? So we will need to look at this nature, the last element of partnership, with a view of profit, referring to intention to make a profit. So also there are conflicting judgments from the court. So definition of profit, and we can, in the case Spanish prospecting, so normally it's referring to net gain made between accounting periods, which is available for distribution. So a question is intention to make a profit. So how we interpret it, what that means, intention to make a profit. So in the case vice and perpetual trustee, so the court expressed the opinion sharing of profit is an incident of partnership rather than its very essence. So it's not necessary, the court found in this case, to share a profit had to be the essential element to determine whether a relationship is a partnership or not. But following this finding, so the partnership, as long as they form with a view to make a profit, so they think if the partner at the beginning they intend to make profit, and that's sufficient determined for this element with a view of profit in this case. But on the other case, Smith and Anderson so expressed the opinion and think still essential for partner to participate to some extent in profits. So in this case, the court think to some extent they still expecting profit is important. So it's different opinion to the vice and perpetual trustee that case. So how to determine existence of partnership apart from Section 1 of Partnership Act? We have Section 2 in the Partnership Act. So there are some instructions for the court to have regard to certain rules in determining whether a partnership does or does not exist. So including how the profit is owned. Well, next week we will look at some different aspects, for example, partnership property. So how property is owned within the partnership, whether gross returns are shared, receiving a share of profits. So it's obvious, apparent evidence of partnership. So it shows member of the partnership, they receive profit, but it does not necessary to decide it or determine, and that relationship is a partnership. So the court will look at all these different aspects of the relationship. So for example, how the property is owned. We have a case, Kenny and Gabriel. So properties belong to partnership, but not necessary. That is to the members of the partner. The partner's share in the partnership is not a title to the specific property, but to a right to his proportion of the surplus after the realization of assets and the payment of debts and liability. So important here is a right to his proportion of surplus. So in this case, the court have the finding how to see the partnership property. So in this Kenny Gabriel, this case, we can have a look the reading material. So it's an entertainment contract between Volume Cell and for media management and Kenny Gabriel. So they have arrangement. So on the outset, they regard themselves as a joint venture only. So they don't think they are going to form a partnership. So only one single concept. So they arrange, and they were going to, after the concept, they share the proceeds of the ticket box. So the case, the legal issue here is whether Wall Lim Saeo and Kenny has the first claim on the proceeds of the project. So there are some conflict here because the court need to determine and whether Kenny Gabriel is a lender or a partner. So the agreement between 4MM and Wall Lim Saeo specified it was a joint venture for profit only. So the profit will be shared between them. There is no joint decision making, and the 4MM and Wall Lim Saeo were joint venturers. So one provide finance as a loan to the joint venture and repayable prior to the distribution of profits. The other provide management. So that's the arrangement of the contract between them. So the High Court's decision for this case, they found Wall Lim Saeo was a partner, not a lender. So Wall Lim Saeo's right to box office receipts prevail over Kenny's charge. So this finding was made despite there being a single venture. This case important because they regard themselves as a joint venture, but the court found they satisfy all the elements of a partnership. So they found they are a partnership rather than a joint venture. So the court looking at the nature of this relationship, profit sharing, joint management and control, and concern with each other's financial stability. So when we compare partnership and joint venture, they have similarities between them, so they can form together, so sharing the profit, and they participate, manage the business. So we will need to look at what's the difference between the two, so you can distinguish, because the difference is for joint venture. Normally the joint venturer, they only liable for their own proportion or specified obligations in the contract, but for partnership, partners, they have unlimited liability. Partnership is an unincorporated entity, so all the partners, they jointly and severally liable for the debts of the business. So there are differences. In this case, Kenny Gabriel indicates the potential for confusion with joint ventures. So we also have another case, United Dominions Corporation Proprietary Limited. The High Court so make a finding, a partnership despite being a single commercial transaction. So when we're referring to partnership, one element is mutual agency and also in common carry on business. Carry on business, we're referring to the nature of repetition. But in this case, one single transaction, the court still found the relationship is partnership. So because they satisfy the other elements of partnership, so the enterprise had a view of profit. The profits were to be shared. Management decisions were a matter for joint agreement. So in those aspects, we need to really look into the fact of the circumstances. So on the face of the agreement, probably they specify they only do this one goal concept joint venture arrangement, but in fact, and they have joint decision making, they have profit share between them. So we look at the in common nature, mutuality, so the reliance between the members of the relationship. So though because of the operation of this relationship, the nature, the mutual agency, so it can be found that actually the relationship is a partnership, even though they regard themselves as a joint venture. So important we make those distinguish between them. So for the partnership topic, part 1, we focus on the definition of partnership. So 3 important elements. There are cases to interpret and what that means. Carry on a business. So what that means, business, section 1b. So carry on repeatedness, and also single transaction can be regarded as carry on a business as well. So we based on the fact of the circumstances. In common, the most important element is mutual agency. So we have the Playfair Development and Rudolph's sleeping partners. So the management role for a partner is sometimes it may not necessary they join in to the business to manage, make the decision, but they behind the scene, but they have their influence in the decision making. So we call sleeping partners. So in common mutual agency. So this is important for the most important element of the partnership. So with a view of profit, intention to share profits, as there are conflicting findings in the case. So first thing is what that means. Profit is a net gain of the business. Is ready to be distribution. So whether actually the partnership or in the partners and actually received the share of profit in some cases is not essential to determine whether there is satisfy this element with a view of profit. But some other case, the court will find still the partners, they expecting to some extent they will share the profit. But if the partnership make a loss, it doesn't necessary to defeat the partnership's existence. So, and these 3 elements are the most important. Then we will also need to look at section 2 of the partnership. So section 2 is, there are some 5 different examples and how the court regard as some circumstances for sharing of profit. So for example, if a partner receives profit by the other one paying the debt, so whether you can regard as this satisfies sharing of profit, so and can be regarded as form a partnership, satisfy one of the elements. So section 2 of Partnership Act, there are 5 different situations, or like receive rent or receive a remuneration of the from the employer, and whether that will be regarded as satisfy sharing of profit. So they important for us to review in section 2 as well. So next week we will look at part 2 of the partnership. So part 2 of the partnership, and we will have some seminar exercise. I just remind us, and I upload some seminar questions each week. So you will require to look at those questions as well before the seminar, right? Okay, thanks. Yes.
I just want to change your seminar because I'm sorry. Yes, this is my timetable. This is my seminar, and got my trouble to lecture, so I wanna from change
So
to
which seminar you enroll in?
yeah, this one.
Seminar 2.
I
Yeah,
want
so
to
this afternoon.
yeah
Yeah. So what's the, you want to change to
change
other?
to Thursday, 10:30
You need
to
to email me, right? Email me if you have clash of your other timetable. Send me an email,
Okay.
right? Then and I will check your records. We can't do it here. Right?
Yeah.
You tell me and which
okay.
your
Email?
timetable. You email me.
So this is
So yeah, my email address there. Yeah.
okay.
Email me, okay?
Okay.
Yeah,
Thank
yeah.
you so much.
You're welcome.
So these questions, do we have to write them